to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did.
All right, guys, this one's a full-blown courtroom circus. We've got a self-proclaimed sovereign citizen who clearly thinks laws don't apply to her, and she's about to learn the hard way that reality doesn't care what you believe. From the moment this hearing starts, she's talking over the judge, arguing with officers, and flat-out refusing to acknowledge the court's authority. Like, imagine thinking yelling "no jurisdiction" is a get-out-of-jail-free card. Spoiler alert, it's not. The judge here? Absolute no-nonsense. He's calm at first, trying to keep things on track, but you can see his patience draining by the second. Every time he tries to speak, she cuts him off with, "The court lacks jurisdiction," over and over.
No, come on out. This is the date and time set for sentencing. The record to show the presence of the defendant. Our advisory counsel is here. Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacks jurisdiction over the subject matter.
What is your date of birth?
The court lacks jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacks jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C, ARA...
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. Turn it off.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now.
Or like a broken record. At one point, he's literally reading her charges, fleeing law enforcement, burglary, resisting arrest, and she's just shouting back about maritime law or something. Meanwhile, the courtroom officers are standing there, stone-faced, probably wondering if this is real life. But here's where it really hits the fan. As the judge keeps listing her convictions, she starts spiraling. She refuses to sit still, starts arguing mid-sentence, and demands they let her go. The judge keeps his cool, but eventually they have to restrain her. And honestly, watching this unfold is like seeing delusion in real time. This woman has convinced herself she's untouchable, and then gets physically strapped into a chair while claiming she's free. You can't make this stuff up. What's wild is the judge still goes through every legal step, calmly explaining her charges, her prior cases, and how this new set of crimes happened while she was already out on bond. So yeah, double trouble. Meanwhile,
Non-dangerous. I'm finding them
Why are you allowing that?
I'm finding, you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up?
No.
You're not? Okay.
But I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing. Y'all being illegal. The court lacks jurisdiction over the subject matter. Y'all don't have no right.
Well, she's yelling that the microphone being on is illegal. It's pure chaos. And you can tell everyone in that room has just reached their limit, and I'll be honest, people like this don't just wake up one day and decide they're above the law. This kind of delusion takes years to build. Somewhere along the way, she replaced reality with YouTube conspiracy videos and Facebook legal myths. She's not fighting for justice, she's fighting against gravity. So after dragging this circus through hours of nonsense, the state finally gets its say, and they don't hold back. The prosecutor lays it out crystal clear. This woman wasn't just reckless. She was dangerous. She was already facing charges, got released on bond, and went right back out and committed more crimes. The burglary alone shook the victims so badly, they didn't even show up to sentencing. They'd already had enough of her chaos. And the judge? He's done playing games. You can hear it in his voice, calm, deliberate, but firm. He goes count by count, stacking her sentences like bricks. Unlawful flight from law enforcement.
Just a second, Your Honor.
I ain't never been biting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-727?
Yes, I'm sorry, ARS 13708.
It's illegal.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims' presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5.
If you enjoy content like this, make sure to leave a like and subscribe to the channel. It really helps me out a ton, guys. Let's get back to the video.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did he give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else?
3.5 years. Burglary, 5.5 years. Resisting arrest, 3 years. And because she committed these crimes while out on bond, each sentence gets an extra 2 years slapped on top. All told, she's looking at nearly a decade behind bars. And when he finishes, she actually asks, "Wait, how much time did you just say?" That's when it hits her. The fantasy's over. The best part? The judge even offers her a lawyer for the appeal, and she refuses because of course she does. She's been denying the system the entire time, and even now, standing there in cuffs, she still thinks she can outsmart it. But the judge keeps his composure, wishes her luck, and ends it right there. You can feel the relief in the courtroom when it's finally over, and honestly, these sovereign citizen cases never fail to amaze me. They always start the same. Someone convinced they're smarter than the law, and they always end the same way. Handcuffs, sentencing, and a one-way trip to prison. But what really sticks with me is how common this mindset has become. Every week there's another one of these. Someone screaming about jurisdiction or freedom from maritime law while getting escorted out by deputies. It's not rebellion, it's denial, and it's ruining lives faster than they realize. Because here's the truth. No matter how many YouTube videos you watch or laws you quote from Facebook, the courtroom runs on reality, and reality always wins. So yeah, let me know what you guys think. Was this one the most delusional sovereign citizen yet? Or just another name on a long list of people who tried to argue with gravity and lost? Drop your thoughts in the comments. And trust me, you'll want to stick around. The next case makes this one look like a warm-up.